In the studio, our good friend Mike Hurst, former U.S. Attorney. Morning, Mike.
Good morning, Gerard. Thanks for having me.
First question is, did you do your patriotic duty and pay your taxes yesterday?
Yeah, I paid my taxes. I'm an old federal prosecutor, so I still pay mine on April 15th. So I paid them.
Okay.
I paid them weeks ago.
I got you.
You know, it's fun. Just a side story, real quickly. I once prosecuted a tax protester, and it just so happened that it came out in court that his birthday was on April 15th. So anyway.
I don't think the government gives you a pass if your birthday's on the tax day.
Well, it just goes to show that he has knowledge of that particular day.
I got you. It's not like it's right. I got you. Awesome. Well, Rhino and I, we did the show Friday, and about 2 hours later, all hell broke loose when the Supreme Court says that 65 deal's out of here.
Right.
And, wow, that just started a firestorm of commentary, analyses, and rebuttal, etc., and in some circles, celebration.
Yep.
But I'm just going to start off with this question for you, Counselor. Did the courts get it right here?
I think they did. I know a lot of Mississippians, at least 74%, are upset with the outcome, with the result. But at the same time, I think we as Mississippians should frankly celebrate this decision because it confirms the process of judicial restraint. And that's what we as conservatives believe that the courts should be doing. They should be reading the text of the Constitution, the text of statutes, and restraining themselves because their job is to interpret the law, not to make the law, not to change the law. Their job is to interpret the law, and they have to use the Constitution as the backstop, as the foundation in our form of government. And I think, as we talked a little bit before we came on the air, you have conservative jurists on the Supreme Court on both sides of this, in the majority opinion of this decision and in the dissents in this decision. So it just goes to show you that even conservative jurists can make different decisions. But at the end of the day, I think the Supreme Court here, even though it makes a lot of Mississippians mad, I think procedurally, substantively, from a constitutional standpoint, got it right and said the plain meaning of the language of the Constitution means what it says.
Yeah. And, it's a good point, Mike, about conservatism and applying conservative approaches here. But here's what I would offer, and I want you to react to this. This was not a matter where ideology should have even been at play. This was a math issue, a text issue.
Right.
This wasn't a matter of, does the court think that medical marijuana should be lawful? That really weren't they were considering.
No.
That's not what was before them.
Yep.
Or that people should have the right to have a medical marijuana program if they choose. This was really about a very thorny technical issue with respect to the signature gathering process.
That's exactly right. So just to give a little context, for the last 130, 140 years, the only way, until 1992, the only way to amend the state constitution was through a legislative process.
Okay.
And then in 1992, the legislature changed that process and said it can be either amended by the legislature or by the citizens' initiatives. And so really, if you think about it, for only the last almost 30 years have we had this citizen-initiated process.
Okay.
But you're exactly right. At the end of the day, it comes down to the court interpreting the language of the Constitution, and for this citizen initiative process, the legislature wrote that initiative and said that the signatures had to be 1/5 of each congressional district. And if you read that language, just plain on its face, we as lawyers are taught in law school, you read the language from a textualist standpoint.
Okay.
There's many different judges' interpretation, statutory interpretation. But if you look at the language of the law and statutory interpretation terms say, if it's plain on its face, then your interpretation from a judge's standpoint stops there.
Yeah.
And that's what this court said. Congressional district means congressional district. It means what you and I think it means, which is I live in the 3rd Congressional District and I vote this way.
Yeah.
What the dissent in this case said was, well, state law, because if your listeners remember, a group of federal judges changed our congressional districts because the legislature didn't do their job.
Yep.
But state law still says there are 5 congressional districts. Mm-hmm. And the dissent says, well, that should hold for purposes of this constitutional amendment. Well, that's crazy if you think about it. That means the statute, which could be passed by a majority of the legislature, could then change the Constitution. And that's not the way our form of government is set up. That'd be like saying that a statute passed by Congress could change our Second Amendment right to keep and bear firearms.
Right.
That's not what we as Americans believe. We believe the Constitution is the bedrock foundation of our form of government. And constitutions control statutes. Statutes don't control the Constitution.
Yeah. No, it's a great point, but I just wanted to, I think, kind of clarify that this isn't like, say, as complicated a matter as gun rights or the subject matter itself, or let's say abortion. Those are very complex matters because you get into things that aren't plain, I think it's maybe fair to say. But this is a math issue. I mean, so math is fairly finite, fairly plain.
And this language is fairly finite and fairly plain, which is, to your point, 1/5 of electors from each congressional district.
That's what it says. Yeah.
And so if you only have 4 congressional districts and you can only have 20% from each district, 20 times 4, that's 80% of the vote. And so you never
math
get
doesn't
to
work.
No.
All right, so
even a dumb lawyer like me can do that math. So,
all right, so tell us the 3 who dissented. What was their basis?
So
for that?
it was.
Is that right?
Yeah, that's correct. It was Justice Maxwell, and then Justice Chamberlain from North Mississippi, and I believe someone. Let me just look real quick. Somebody joined in with Justice Chamberlain on his dissent, but basically their point was, Justice Maxwell's point was, you had 3 federal judges decide our new congressional maps. And so we should not allow federal judges to say our constitutional terms or sections are invalid.
Gotcha.
But again, that doesn't make sense because, as the majority pointed out, the legislature, when they drafted this back in 1992, when they put 1/5 in the language, they knew, both legislatures before and legislatures after, that every 10 years we do the census. And every 10 years we decide what the congressional makeup is going to be. And even in the Supreme Court arguments, Justice Beam brought out the fact that in 1900, Mississippi had 8 congressmen. And then it started going down and down, 5 in 1992, and now we're at 4. So the legislature knows that we lose or we gain congressmen. Right. And so by putting 1/5 in there, they could have easily put in I think like Senator Watson has said, or Secretary Watson now has said, they could have put in there pro rata share, which means however many congressional districts we have, you break it down on equal terms. Yeah. But the way that Justice Chamberlain wanted to do it, which was saying current state law says we have 5 congressional districts, even though that's not true based upon the federal judge's decision. Current state law says we have 5 congressional districts. Therefore, even though that doesn't really apply for congressional districts, it should apply for this initiative. Yes. But again, the problem with that is the legislature could change that tomorrow and say one congressional district is Hinds County. Yeah, exactly. One congressional district is DeSoto County. So they can manipulate the initiative-driven process in the Constitution just by a majority vote and changing a statute. And again, that's not what any, I think, Mississippian would want. No matter how fervent you are for marijuana or against marijuana, we have to go back to the Constitution and we have to give effect to the words of the Constitution. Otherwise, words don't mean anything. And we certainly need to protect the integrity of the ballot initiative process. Absolutely. I mean, the bar is fairly high, but it should be. It should be. That's exactly right. And we shouldn't just be throwing anything and everything into the Constitution. Again, the Constitution should be the bedrock foundation for statutes and laws that the legislature makes. And if you look back over that 100-year period from 1890s to 1992, there were multiple constitutional changes that were driven by the legislature, that was passed by the legislature. So the legislature has shown in the past, at least, that they can do their job. The question I think JT raised it yesterday was, why are they not doing their job now? Yeah. And that's why we, had voter ID. That's why we had eminent domain. That's why we had all these other things. And that's why you're going to continue to have it. But the question is going to be now, does the legislature change the current initiative process? Because the legislature can still amend the Constitution. It's just now, as it stands, because of this decision, the citizens cannot go straight to that initiative process.
Gotcha. And I want to talk about that after the break, sort of the mechanics of that, where we go from here. Stay with us, folks. Kind of the framework and the purpose of allowing citizens to get something on the ballot, a measure on the ballot, is more of a straight Democratic approach to governing as opposed to a representative Republican approach. We elect representatives to make laws on our behalf. And in this situation, at least in Mississippi, you're actually amending the Constitution.
Right.
You're not establishing or amending statute or law. That we don't have such a provision in the state of Mississippi.
Right.
Some states do. Some states have a Constitution only. Some states have, I believe, Constitution and statute. I'm not sure if there are any states that have statute only.
Right.
I'm not sure of that case, but that's kind of irrelevant. So explain to us what some of the risks are of such a mechanism.
Well, it gets back to, like you said, are we going to have a direct democracy? And why do we have a legislature if that's the case? Or we're going to have a democratic republic.
Yeah.
We're going to elect our representatives to represent us in this legislature. And I think it goes back to JT's point yesterday, which is if you have an issue, then you wear your legislator out. You wear them out because they represent you. Our form of government is the will of the people governs. But the problem with, sometimes I think the problem with citizen-driven initiatives is it's written by someone, as in this case, this lobby for, outside interests. These outside interests spend millions upon millions of dollars campaigning and marketing this. And I think a lot of the citizenry don't really know what's in it. And I think that was Mayor Mary's point and JT's point, which is it restricts a lot of the protections that we need to prevent, things coming into our cities or coming into our towns or our communities that maybe those individuals who live in those specific communities or cities do not want in their communities, like zoning rights. That initiative did not adequately address in some people's mind the issue of taxation, the issue of where the money goes, how the money can be used. There are all kind of problems with that because once the initiative has been set, once the signatures have been received, the language is what the language is, warts and all. Yeah. And I think a lot of times that's the problem. One hypothetical, what's to prevent a citizen from starting getting signatures for an initiative that says the state of Mississippi shall pay every citizen $5,000 a month for their life, and then submit that to the people of Mississippi? I
don't think there's anything that would prevent that.
That's
at this
the
point,
concern,
right?
Because we're thinking about the interest to ourselves rather than the duty or the responsibility on the back end.
Yeah.
And that's the concern. That's why we have a democratic republic for those individuals to represent us. I'm not saying they've done it well. I mean, they never addressed the congressional representation over the last 30 years. They never addressed this issue, this citizen initiative issue that they knew was broken.
Yeah.
They tried to address it 6 times, but they never got it over the finish line. And they never addressed the issue of medical marijuana, even after they saw it pass by 74% last year and knew this was coming. They didn't address it this past session. Wear your legislators out on issues you believe in, but don't blame the Supreme Court when they do their job and they stand up for constitutional provisions.
Yeah, I agree with you on that. I think the Supreme Court is just the wrong villain here if you want to say that anybody, I guess, is responsible. And look, early on, and Rhino, I think you'll back me up on this, said it countless times, we're in this predicament because the legislature didn't act. And, I know Joel Bumgar real well. It's no secret. He was the primary party that organized this effort and put a lot of his own dead-gum money in it. And I think he got frustrated and said, I can't get any traction down here at the Capitol. I'll just take this thing on my own and I'll pursue the ballot initiative process. That's his right. And he orchestrated it. He organized it. He funded a good part of the initiative process. He's well within his right to do that. And that's what put us in this predicament.
Right.
And
but as long as and the advantage to the legislative process, as messy as it is, as much as a sausage making factory that it is, the advantage is individuals from different interests with different ideas and seeing around different blind spots can come to a compromise that addresses a lot of the issues that an initiative that is written in stone, cannot be changed, has to be voted up or down by the citizenry, and then we have all kinds of unintended consequences.
Yeah, so, you're exactly right.
But I think Rhino nailed it yesterday. He may not know this, but he agreed with Chief Justice Roberts when he said, judges are umpires. They're just calling the balls and strikes. They're calling, if you don't touch third base on that grand slam home run, it's nothing personal. I didn't want one team or the other to win.
Yep.
My job is to enforce the rules, to enforce the law. And I think, again, despite where you come down on marijuana, I think the Supreme Court did a admirable job in doing that.
Knowing it was likely to be an unpopular decision.
Absolutely.
Based on the votes.
Absolutely.
At the ballot.
But again, our country's history is filled with unpopular decisions that have given way to us seeing the wisdom in those decisions.
You have to protect the integrity of the system.
Yes, absolutely.
Because if we don't have integrity in the system, then we all lose.
That's
frankly,
right.
in that situation. Yeah, Rhino did make a great metaphorical example there. So where do we go from here?
Well, I'm not in the legislature, so you might want to call your senator or your legislator.
Well, the speaker says he's for convening a special session to address the ballot initiative process, the broken aspects of that. But I haven't heard specifically at this point any members of the legislature, the governor, or the lieutenant governor, et cetera, say we need to convene a special session immediately to get a medical marijuana program established. I haven't heard that. Maybe some of our listeners have, Rhino. I haven't seen any talk of that, and I wouldn't expect to at this point. I think everybody's kind of laying low to see where the cards show up there.
And those are the two big questions. I mean, the legislature can address both of those. The legislature can put that ballot initiative back on the ballot to be voted on by the citizenry, or the legislature can just move forward and pass medical marijuana without any more involvement of the citizenry. It can do that job. It could have done that job this last legislative cycle knowing that this might happen.
Yeah.
But it didn't.
Well, I think Joel's been pushing for it in the Capitol for a while. He's passionate about the issue, and so he's, in his fifth year, I believe now? So,
but I think we should be, even if you disagree with the result, the outcome, the fact that medical marijuana is now not viable in Mississippi, even if you disagree with that outcome, you have to respect the decision and the way they went about doing this decision and just looking at the specific terms in the Constitution. Again, the legislature wrote that term, and the legislature can go back and fix that term. That is Democratic, Republican government at work.
Yeah.
Call your legislature or get them to change it if you want it changed.
Well, and so another question I would ask you, in your opinion, should we have a ballot initiative process that would allow the citizens to establish or amend law?
It's an interesting question because, again, even though it feels like we've always had this right, it's only been on the books for about 29 years.
Yeah.
So let's look at what it has done. It has accomplished eminent domain protection. When the United States Supreme Court said that governments can take your private property for a private developer.
Yep.
Basically, Justice O'Connor said that decision basically says I can take your house and turn it into a mall. I can take your farm and turn it into a factory. I can take your Motel 6 and turn it into a Ritz-Carlton. The government can do these things. When the United States Supreme Court decided that, I think about 44 states responded. Thank God that, I guess we reinvigorated the 10th Amendment here, but 44 states responded and said, no, that's ridiculous.
Right.
That's not who we are as a people. And that included in 2011 the citizens of Mississippi.
Yep.
But again, the question is on the table, is that going to be under judicial scrutiny now?
Yeah.
Voter ID. And Aaron addressed this yesterday. Voter ID is in a similar situation, but I think it's in a better situation because the legislature came back after the Constitutional Amendment was passed and put into statute voter identification requirements. So I don't think voter ID is necessarily in peril as much as the eminent domain is if anyone were to challenge that.
Well, the question came up, and Aaron said he answered affirmatively, could a party challenge a law? could they go take it to court and say the law, like such as voter ID, it's just unconstitutional?
Absolutely, because that's what Aaron does for a living.
That's exactly what he said.
Does.
That's exactly what he said.
That's
he
why I started
it. Exactly. He challenges laws on the books
Absolutely.
all the time.
Just because the law has been on the books for years does not mean it is unconstitutional. This is why we are where we are today. That law has been on the books for almost 30 years.
That's right.
And the Supreme Court has now found that constitutional amendment unconstitutional.
All right, we got a break. We got a good discussion. You want to hang around?
Absolutely.
Yeah, we got Mike Hurst, former U.S. attorney. We're talking about Initiative 65 and all kinds of fascinating legal facts and analysis from Mike. We've got Mike Hurst, former U.S. attorney, in the studio. We've been talking a lot, Mike, about all the legal nuances, shall we say, associated with this Initiative 65. And what's interesting about this, it's not only the initiative itself and the establishment of a medical marijuana program, but it's the ballot initiative process that's been brought to light, and that's what we've been talking about. So we have one listener that says, if the legislature fixes the initiative process, I hope they include language saying you cannot use the process to create an entitlement, such as, he says, Medicare expansion. It's really Medicaid.
Right.
So that, and then you get into a situation where you're
what's
asking,
the definition of entitlement?
Yeah. Well, and you could, what other matters should not be, permitted for?
Well, and it's kind of to JT's point yesterday, and I've heard this point raised a lot, is, do we really want to enshrine into our Constitution specific products like marijuana? Do we want to use that process to put specific preferences for things or items or products into our Constitution? Our Constitution is supposed to be kind of the broad general framework of what we believe our form of government should be. The right to bear arms, no due process without life, liberty, or property, things like that. Big general ideas. It shouldn't be, you have to go down to the corner store and get approval from this person to sell this product. I mean, the specifics is what should be worked out in our legislature. Yeah. And again, if you are upset with this issue, wear out your legislature. Their job is to represent you. Yep. And if they're not doing their job, we'll find another legislature.
Well, one question I've thought about is I wonder how many people actually asked of the candidates let's say in 2019, where do you stand on medical marijuana? How important an issue was that? And did anybody, say, cast their vote on the basis of a candidate's position on that?
Right.
Now that it appears to be very popular, obviously, based on the vote, but now it's been struck down, and we got to rely on some other mechanism, likely the legislature, to create a program. I wonder how important that was to people, and if they asked them.
Yeah, and I don't know. All I know is the fear I had from the unintended consequences of this initiative, with the amounts, with the generic language as to who could get a prescription, with the taking away of the local citizens' right to zone this in their particular counties or cities. This takes away a lot of control of individual citizens while giving control to a lot of out-of-state groups.
Right.
For their financial benefit, frankly.
Yeah.
At the expense of us.
Well, I'm not sure how much of our audience realizes that the state of Alabama just passed a medical marijuana program, and I did a little research on that, on some of its provisions. But with respect to the number of dispensaries, I believe is what they are referred to in Alabama, I think the limit is 27 across the state. And let's see, licensed dispensaries. The legislation allows up to 27 locations. A commission that they would form to oversee the entire program, that's also in the statute, would issue dispensary license, not sure how to say that, to as many as 4 companies that could have each 3 dispensary sites in separate counties. So that's an interesting approach. I don't know where they came up with 27.
Again, I think it's in the providence of the legislature to analyze these 35 or so states that have already done this and come up with what works best for Mississippi.
Yep.
We should not be putting into the Constitution, generic language that has all these unintended consequences that I think are going to adversely affect many Mississippians. And so, again, legislature, do your job, get together, come up with a compromise, and do something if this is what your constituents want.
Yeah, it also does, the Alabama law says dispensaries could locate only in cities and counties whose governing bodies have approved them.
I mean, that's what we as Republicans believe. We believe the best form of government is that which is closest to us.
Yep.
And so, I applaud Mayor Mary for standing up for her citizens in the city of Madison. That's what, they're the ones that we hold responsible. They're the ones that we have probably the most contact with of those, mayors or councilmen or whomever. And I think it's we are doing ourselves a disservice when we complain about the federal government and federal overreach and states, and we want states' rights, and yet we don't complain about the state taking away sometimes the right of our local elected citizens.
Yeah, I totally agree.
And it goes back. It goes both ways now. I mean, the state took away sanctuary cities for some of our local elected. It's not perfect, but again, I think the best form of government is that which is closest to us.
I totally agree. And anyhow, appreciate you coming on today, Mike. It's been a good discussion, and thanks for clarifying much of the legal complexities.
Well, I don't know if I clarified anything, but I think the Supreme Court got it right on this one procedurally.
Sounds good. We'll take a break right here, folks. We got news on tap for you. The JT Show continues after that.